Welcome to the From Lab to Patient, Garage to Market podcast with your host, Phi Crowley. In each episode, we will discuss professionals serving the tech startup market and the various issues of importance to those companies. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, CrowleyLawLLC.com. Now here's the host of From Lab to Patient, Garage to Market, Phi Crowley.
Welcome, and thank you for joining our podcast today. I try to bring to these podcasts experts and participants in the startup world and the technology world who can share their experience with you so that you have a sense of what actually goes on, what are some of the opportunities, what are some of the risks, to educate yourself about the process and to feel more comfortable about taking that giant step of setting out to create your own company. Today, I'm delighted to have with us a colleague, Anne-Marie Yvon, who is a registered patent attorney, a very skilled attorney in the filing, management, and strategic planning around patents. Patents are an important part of the value proposition of life sciences and technology companies. And I'm so happy to have Anne-Marie with us today. Anne-Marie, welcome.
Well, thank you for that kind introduction and for having me on today.
Well, you're kind of really understated for our audience. I wanted to let them know you have quite a distinguished academic career, a Ph.D. in molecular and cell biology from the University of Massachusetts at Amherst, and then work as a scientific consultant and then as a patent lawyer, and then worked for a very prestigious firm, Wilmer Cutler, and then decided to take the big entrepreneurial step on your own and form your own law firm. But I'm interested, how did you decide that you were going to take all of that great scientific knowledge that you had developed and apply it, instead of in the laboratory, to law?
Well, it is an interesting story. I was finishing up my PhD. I had gone to grad school intending to become a college professor. That was the intended career path. And I got to the end of my PhD program, and there were a few different avenues open to me. One was to pursue an academic postdoctoral fellowship. Another was to go into industry and work as a scientist. And both of those things were sort of interesting, but I found myself kind of asking, what else could I do with this degree?
Mm-hmm.
And so I started talking to people. As you know, and probably as many of your listeners know, networking is huge. So I just started talking to people who had been in science and asking them kind of, what do you know about alternative career paths? And it so happened that I met someone at a party who had gotten a PhD and gone into patent law and was working at a firm in New York. So that kind of set me on the path in the first place to investigate this, what was considered at the time an alternate career path.
Mm-hmm. And how did you wind up going to law school? It looks like you had a full-time job while you were doing that.
I did. So at the time I first moved to New York, I got a job at an IP boutique. It was at the time about a 35 attorney firm. And there were several of these in New York at the time who would hire PhD scientists directly out of the lab and train them to be patent practitioners. So something that people may not know is anyone with a scientific or technical background, such as engineering, chemistry, biology, computer science, you can take a separate bar exam and get licensed to practice before the U.S. Patent and Trademark Office without going to law school and becoming an actual attorney. And so then you practice as a patent agent. And so I did that, and that is the career path for many people. For others like myself, there was the opportunity to go to law school at night and kind of further my education so that I could get a law degree and move from being a patent agent to being a patent attorney. So that's what I and many of my colleagues also did.
Mhm. How did you decide to leave that patent boutique and go to this large, very prestigious firm, Wilmer Cutler?
It was I had been at the first firm, the IP boutique, for about 7.5 years, for a few years before law school, and then all during law school. And I learned so much there. The firm itself was fairly new when I joined. They had only been in business about 3 years themselves,
Mhm.
and so they were growing, and it was exciting times. But I got to a stage where I felt like I wanted maybe a different experience, a different platform to be able to develop my career path a little more. So at the IP boutique, I learned how to write a patent application, how to deal with the patent office to be able to get patents for my clients, um, and how to do certain analyses like is your is your idea even patentable? If
Mhm.
you want to develop your product, are you going to be infringing somebody else's patents? That we want to make sure that before you get too far down the road in your research and development, you have a clear path, you have freedom to operate. So
Right.
that sort of analysis, I felt like I had a very good foundation. But Wilmer Hill presented the opportunity to work, as you say, at a large multinational firm. I was able to get in on the litigation side so that I could see what happened 10 years down the road, right? Most patent
Mm.
practitioners, you get the patent, they mail you the copy, and you say to your client, here you go. And you may not have any interaction with that patent, so to speak, going forward. So on the litigation side, you get to see 8, 10, 12 years after someone has gone through that process with the patent office, what may happen to the patent after that when either somebody wants to challenge its validity or the patent holder wants to enforce it against potential infringers. So the chance to take my practice in that direction, and again to just work in a different environment, with a broader set of attorneys was very appealing to me. So that is why I went to Wilmer Hale.
Well, it sounds like you had an opportunity to learn how to be much more strategic about patenting, seeing what happens down the road. Then you can bring that back to how you draft a patent or put together a patent strategy so that you can anticipate what problems may occur down the road, 5, 10 years down the road, and try to structure your advice and structure the patent strategy generally to try to minimize those risks. I know you had an experience of using and helping a small biotech company in a litigation against a big company. Can you tell us a little bit about what happens? Because sometimes I don't think innovators understand much about the litigation practice that surrounds patents and the decisions that they may be called upon to make in that process. And you seem to have a lot of experience in that area.
Absolutely. So a lot of times these litigations are just one giant company against another giant company, and that's one set of issues. But in the case that you raise, we had a small company. It was a startup, doing really great science, really exciting stuff. They're still in business 10, 12 years later. So,
Mhm.
you can see that they were on the right path, because that is a difficult row to hoe for startups. And they were in competition with a large company that thought that the products our client were developing would infringe their patents. And so our client was sued by this company for infringement. Um, of course, nobody wants to be involved in a lawsuit, but part of our job as their legal team was educating them. This is what to expect. This is this is how this will proceed. And it's not only the the legal advice of should we make this argument or should we call this witness, but it's a lot about educating the client about the whole process and about
Mhm.
the strategy that we're undertaking the whole time, and just the nuts and bolts of, okay, this is what we do in fact discovery, these are the steps. This is what we do in expert discovery, these are the steps. Here's how we find an expert. Here are the things that you need to think about with your internal people in terms of who we might need to speak to, who might need to help make our case for us. So it's it's kind of a whole, we if I were in medicine, I would say treat the whole patient, right? We take the
Yes,
whole company and we try to help them through this process, which is very stressful, and
of course.
and we try to break it down in smaller bites so that it seems less overwhelming and they have confidence that we've got them.
Well, that seems to be incredibly important, and particularly since litigation can be so expensive, and the resources of the big company far exceed those of the smaller company. So I can understand how it can feel very as an existential threat for the smaller company in terms of whether or not they'll be able to succeed and continue to develop their products. You deal
Absolutely.
with a lot of startup companies and smaller companies. What are some of the key elements that you try to help them understand right up front to help them protect themselves maximally, when they get to that point 10 years down the road when somebody may be thinking about suing them?
Like, um, so I will just say I love startup companies. They are really my favorite kind of client to have. And I'll tell you why. It's because I do really like that fulsome involvement in the business. And when you represent a large pharmaceutical company or a large research institution, you're much more of kind of a cog in a giant machine. Whereas for startup companies, I get to interact with founders, I get to interact with the scientists and the people who are really doing the work and making the company go.
Mhm.
Um, so it, one thing that is just essential is IP, right? When you are a small company, you're a startup, you have no products, all you have is your intellectual property, your ideas, your vision for what the company will be. And so it's really important to talk to patent practitioners early on in your process. You may not be at a stage yet where you need to file a patent application. You may be at a stage where you're considering in licensing some work. A lot of these
Mhm.
small companies, as you know, are spinouts from academic
Right.
institutions, and so there is some foundational work that's already been done, and maybe there's a license being contemplated to existing patents or patent applications. Getting advice as early as possible in that process is really important because it allows you and your patent attorney to develop a shorter term, a medium term, and a longer term strategy for how you're going to develop your portfolio. And that's
Mhm.
much easier to do early in the process than if you're already a year or two in, and then I have to come in and say, okay, well, we went down this road, which isn't exactly the road I might have gone down if we had talked a year ago, but now here are the options, right? So the earlier you do
Right.
it, the more flexibility you have to plan in advance. So I would say that's the biggest piece of advice I have is to just consult with an IP practitioner early in the process. And like I said, it may not be that you need to file a patent application or take a whole lot of steps first off, but if you are armed with that information at an early stage, that helps you to develop the portfolio in the way that's going to serve your business best.
Mhm.
And by the same token, I mentioned earlier freedom to operate. Before you put too much money into developing a product, you want to make sure that the Pfizers and the J&Js and the large companies of the world aren't going to come after you after you've put your hard raised money into product development, and then you find out, oh, somebody else has some patents that might block my ability to bring this product to market. So that's another aspect. You want to know that early, and not wait too long.
Right. All right. At this point, I'd like to take just a minute to introduce our audience to Crowley Law. We are a boutique law firm focused on helping life sciences and other technology innovators and their companies realize their dreams to take great ideas from the laboratory bench to the patient's bedside, or from the garage to the marketplace, to enrich the lives of thousands or millions of people. I'm a former physicist who has been a technology junkie for a long time. And I have this passionate belief that technology properly applied can do tremendous things to improve our society. And so I have a great feeling of affection for innovators out there and like to focus our efforts on protecting founders and their companies from making expensive legal mistakes that can come back to haunt them after the fact, giving away too much to initial investors, allowing investors too much oversight and control over the enterprise that you and your co-founders have put together. So we pride ourselves in providing big company expertise with the type of care and attention and communication that only a small boutique firm can provide. And so if you're an innovator out there, please take a look at our website, crowleylawllc.com. Take a look at the free resources we have out there. There is an ebook, The Top 10 Causes of Failure for Technology Startups, and How to Avoid Them. It's been very popular. And then if you have issues or problems, please give us a call or contact us at info@crowleylawllc. We're here to help. Now, Anne-Marie, you spoke both on the planning side about helping your companies, but also on the defensive side. There must be things that you discuss with your clients to help them figure out, how do you protect the potential patentability of information as you're working through the process? In other words, how to keep the genie in the bottle before you're ready.
Right. And keeping the genie in the bottle is hard, right? Because um, often, as I said, small startup companies are somehow affiliated with academic groups. Often there's a relationship there, and academic scientists need to publish, right? That's part of their job. Their job is to do research and then tell the world what they're doing. And that job is a bit at odds with what you're trying to do in a corporate context, because your patent term starts running from your patent filing date. So if you file too early, you might be giving up patent term on the other end when you finally have a product. On the other hand, if you
Mhm.
file too late, then your collaborators may be out at meetings talking about their innovation. So as with anything, communication is really, really important. Um, we have to know, are you going out to talk with investors? And let's talk about, what are you going to say to investors? What needs to be disclosed to give them confidence that you actually have something here, but what kinds of details can we keep kind of closer to the vest and not disclose, that won't impact patentability? So I tell my clients, before you do a potential slide deck for investors, before you send an abstract in for a meeting, before you publish a paper, before you have a department, like anything where you might be speaking to people outside of your organization,
Mhm.
let's talk first about what that disclosure will look like. And if it's really important that you put these details out there, then we file a patent application, and we make sure that we're protected that way. But it kind of is a case by case basis on, do you really need to tell someone this, or can we keep it to ourselves for a little longer? And again, it's educating not just the client, but then making sure that the client contact can talk with everyone in their organization and make them understand that any outside disclosures have to run through a patent practitioner first, and that we hammer that home all the time. And I think I say it enough that I don't usually run into too much trouble. However, if something gets away, right? If you had a rogue inventor who sent in an abstract, whoops, I forgot to send it to you, tell your patent person right away, because there are steps we can take to mitigate any potential damage of that as well. So it's not the kind of thing necessarily that is irreparable, but communication with what kinds of things you're disclosing outside of the company will help your patent attorney give you the guidance that you need. And we're not here to say don't tell anyone anything ever. We understand, right? You're running a business. You have to make business decisions that may sometimes be in conflict with what I would advise you as a practitioner. So I'm not just there to help your patent portfolio develop, but to help your business develop. So there are compromises and there are ways that we can um, decide what to disclose and what not to, and then how to protect what we are disclosing, as long as we're involved in the process.
Well, I was very impressed with your description of what your role is not just to develop the technology, but to develop business. And I think that that's one of the things that distinguishes boutique firms like yours from very large, prestigious law firms that are more focused on the technical details of delivering the legal services, but without kind of understanding the context in which they are delivered and what the end product is. And it kind of goes back to what you said about your experience in litigation, being able to see, well, what happened 10 years down the pike to this particular
Hmm.
thing. But I do want to step back a little bit. Many of our viewers and listeners aren't really expert in patent law and don't know the problems that can occur when something gets into, quote, the public domain, unquote, and why filing provisional patent applications is so important. Could you describe that a little bit?
Absolutely. So the patent process is actually fairly straightforward. It may seem overwhelming because there are a lot of details, but from a 10,000-foot view, you file an application with the patent office, and that kind of that's your line in the sand. This is when my invention is going on record. This is my date. Now, when you file that, it can be provisional, as Phil alluded to, or it can be a non-provisional application. A provisional application is literally just your line in the sand. It does not get examined. It just goes to a repository in the patent office, and then you have 1 year from that date to decide what to do. And the choices are: you can file a non-provisional application in the US, you can file an international application, which will then lead to a process where you can file patent applications in other countries if that's of interest. Or you may decide to do nothing. You may decide that after that first year, your your research hasn't really come along as far as you wish it had, and you think that there's really not enough there, or you think you're going in another direction entirely. Maybe this time last year you were on one track and you got
Mhm.
some results and decided to be on another track. That provisional just gives you the date, and it gives you the flexibility to then be able to go out and talk about your invention to investors or academics or in other contexts. Um,
So
so
the protection there is that then when you have that on file, uh, when you go out and discuss it at your next meeting or in a paper or something, and it becomes part of the public domain, someone can't say, oh, now that it's in the public domain, it's not new and you can't patent it. So an application or provisional application protects against that, right?
Exactly. So I should say there are a number of uh, criteria for getting a patent. And one of them, as Phil alluded to, is that your idea has to be novel. It has to be inventive. It has to have not been disclosed in what we call the prior art, which basically means the public domain. So when the patent examiner gets to looking at what your invention is and deciding whether to grant you a patent or not, they are looking for any kind of public disclosure that describes what you've invented. That public disclosure could be by another group who might be competing with you, or it could be by your own inventors. But if you've filed your patent application before you make that disclosure, then you're protected against your own disclosure becoming prior art. There is a grace period in the United States for inventor disclosures of 1 year, which we can rely on in an emergency, but I tend to strongly discourage doing so because in most other countries there is not a grace period, including in Europe. So if you have the type of product where you expect you'll want to market it internationally, you really want to make sure that before anything goes outside of the company and is disclosed in a way that could be prior art or destroy the novelty of your invention, you want to make sure that you have an application on file. It can be a provisional or it can be a different type of application depending on your needs. And again, that's something that you would discuss with a patent practitioner to determine what the best strategy for that would be.
So it sounds like having your patent lawyer, rather than simply viewing them as a clerk or a scrivener who just writes up the brilliant ideas that the scientists come with, that establishing a relationship with the patent lawyer and having that patent lawyer establish a relationship with you and your firm is an important part of the process of developing really a robust patent strategy that over the long term will protect more of your intellectual property and give better benefits to the founders, their investors, and everybody else who's depending upon the predictability of that particular item. Now,
Absolutely. Yes.
in dealing with startups, you took a big risk, and it's like jumping off, a little bird jumping off and saying, "Well, I think I can fly," and now I'm just jumping off. And you have to have confidence you're going to be able to flap those wings. What has been some of your experiences, the things you love about it, the things that you didn't expect about setting up your own business? Because this is part of the process that our viewers and listeners will be involved in at some point if they decide to pursue their aims.
Yes. And to be perfectly honest, I never envisioned myself as an entrepreneur. I never thought that this was a path that I would go down. And I was a little surprised to find myself doing this. But I have to give all the credit to my partner Julia Grimes, who is a spectacular patent attorney and human being. And she was really the one who pushed me and said, you can do this. We'll do it together. And I actually let her dip her toes in first. So she left WilmerHale and started practicing on her own for about 2 years before I joined her. And then, we were able to expand the
Mhm.
business once I decided to jump off. And oh, what made me do that? I loved working at WilmerHale. It was a great firm. It was a great job. I still have many friends there. But when I thought about life as a big law partner in 5 years and 10 years, was that really the job that I wanted? I decided that maybe exploring something different might suit my desires better. For me, part of that was that the more you advance in a large firm, the more managing and supervising you do, and the less kind of down in the details you are, and I am very much a down in the details kind of person. So I honestly, before I started practicing at Grimes and Yvon with Julia, I probably hadn't written a patent application in 6 or 7 years. I mean,
Mhm.
it just your practice evolves in a different way when you're climbing the big law ladder than if you're running your own shop. So for me, um, the ability to really do those types of tasks that I did early in my career, but with the background of all of my experience and kind of
Right.
understanding um, the importance of different aspects of the tasks I was doing, that became very appealing to me. So there was the practice of law aspect of it. Um, the running the business aspect of it, I just figured it out. I figured out
Yeah.
how to set up QuickBooks, and I figured out how to set up the case management system and what you need to maintain your registration with the state of New York, um, and that sort of thing. You kind of muddle through because I did not have a corporate guru like Phil Crowley on my speed dial at the time to help me set up my nascent business. But you can do it. I mean, there are tons of resources, and what I have found throughout my career is that if you find someone who's doing what you want to do and you ask them how they did it, they'll tell you. People are very generous with their time, with their advice, um, and and networking is just so important. Um, so whenever I've had kind of a question or an issue, I try to look to former colleagues who also may be practicing in small firms and say, how do you handle this and how is that working out for you? And I think that's probably the same in any business.
Well, that is great. Anne Marie, thank you so much for joining us today. The time has really flown by, and I want to commend you for your work and Julia Grimes's work in helping small companies, and remind people that we're here every week talking to interesting people like Anne Marie who have experiences to share and information to share that can help you along your road to success in taking great ideas from the lab to the patient and from the garage to the marketplace. So that's it for today. Hopefully, we look forward to see you next week. Please like and share and subscribe our podcast channel. Thanks so much. Anne Marie, thanks so much for joining us.
Thank you for having me, Phil.
You've been tuning into the From Lab to Patient, Garage to Market podcast with your host, Phil Crowley. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, CrowleyLawLLC.com. If you found this information helpful, please subscribe, like, leave a positive review, and share with others.